Welcome back to the Crypto's Key conversation. In this video, we're going to be taking a look at Johnny Deaton's thread here in regards of Ripple and the SEC can both win. So there's been a lot of questions of, based on everything that's been servicing within the case, like it's quite outstanding how much power and leverage Ripple has in the case, but he's kind of putting up a scenario as to where Ripple and the SEC both win. So we're going to go through that thread. And he's also answering the question of, do you still see this case wrapping up in 90 days? This person asked John Deaton his opinion on it. Stefan Huber had found this video that he says he's been trying to find for a while, which is pretty massive in regards of Ripple's fair notice defense. And then we're going to take a look at Bill's tweet right here in regards of, how are you linking the relationship between Ripple and XRP holders, and you're identifying it as common enterprise, as the SEC says. Also, we're going to be taking a look at the big bombshell, or the big story that came out in regards to the Axie Infinity hack, and they're claiming the Lazarus hacker group of North Korea is a part of it. Huge Metamask warns users of new Apple iCloud phishing scam. And then Kevin OLeary from WonderFi acquires Canadian crypto exchange Coinberry. And then Terra's been on a tear. It says Terra stablecoin UST becomes crypto's third largest, which is massive. So coming over here, looking at CoinGecko, we're currently sitting at a $1.99 trillion market cap, currently up 2.9% for the day, almost sitting at $2 trillion, which is huge. Bitcoin sitting at 40,994, Ethereum sitting at 3,082. XRP sitting at 77 cents, and there's still a lot of green in the market. If I click on this, we'll see who the top gainers are. Don't know what that is, but it's up 37, almost 40%. Terra is up 18.3%. Terra is just massive. Monero, Loopring, there's a lot of stuff going on. Coming over here to the Bitcoin Fear and Greed Index, we're currently sitting in the fear range. So we're not in the extreme fear range like we were, yesterday, last week. And like I've said in videos time after time, this has kind of been our home. We've been laying in this extreme fear range. So we're back in this fear range at 27. So there's still a lot of uncertainty within the markets, and there's a lot going on, a lot of different narratives pushing right now. So obviously the markets are being affected by that. So quickly jumping into the first thread here. This is from Johnny Deaton. It says, Ripple and the SEC can both win. Now that we have arrived at summary judgment time, I see a lot of comments on how Ripple can't lose at all. Not true. It's possible that both sides win, technically and legally speaking, that is. He goes, Ripple and the SEC will agree to a laundry list of agreed upon stipulated undisputable facts. Those stipulated facts can remove the case from being decided by a jury. If the parties cannot agree, a jury decides what actually happened. The jury decides the facts. For example, if the parties in a car accident case do not agree what color the traffic light was, the jury decides. But if both parties agree that the light was red, there's no need for a jury to decide that fact. Hence, Ripple and the SEC could agree to all the relevant facts. He continues, if that happens, the judge applies the law to those set of facts and gives her ruling. Here's a hypothetical example. The SEC and Ripple agree that in February 2013, Ripple sold an option for 1 billion XRP to investor B, valued at 5 cents per XRP for $25 million. Judge Torres, applying Howey factors, could determine that on that day in 2013, investor B gave $25 million an investment into a common enterprise with Ripple, with a reasonable expectation of profit, because Ripple explained all the efforts it intended to make the drive adoption and utility of XRP. If the above factual scenario was agreed to, the judge could find that specific offering of XRP an investment contract with Ripple, SEC wins. Ripple could still win because the judge applying those same factors decides ongoing sales of XRP by Ripple are not securities. Ripple wins. The judge should find that the secondary market sales of XRP independent of Ripple are also not securities. XRP holders win. Here is a brief analysis I did at the 1-year anniversary of the lawsuit related to today's XRP. So if you haven't checked out this Howey test analysis thread, you need to go in here and read this. It's absolutely informative and definitely beneficial to read. So coming over here, Johnny Deaton is responding to the Irish Red Crypto's question here. Says, do you still see this wrapping up in 90 days, John? So when the SEC's motion to pretty much redact and not have to bring out the 68 drafts and these emails to provide them to Ripple in regards to their position within the case. When that motion was denied and the judge said no, the SEC needs to provide these documents, these relevant documents, Johnny Deaton was saying, once they had the 14-day period to object to, or I guess to re-object to that motion from the judge, from that day on, that the judge either denied or say she denied it. So say she agreed with the other judge and said no, you need to provide these. He was saying from that day on, 90 days within that 90-day period, whether it was shorter or all the way up to the 90-day period, that the case would be over in regards of a settlement. So he's responding saying, great question. I said I believe the case would settle within 90 days from Judge Torres affirming Judge Nampern's decision. I still stand by that. However, I didn't really consider Ripple insisting on summary judgment without the emails and documents. In hindsight, it makes sense. He continues, the emails and documents are most relevant to fair notice. Ripple can win on the strict Howry analysis, and if they do, the court never has to decide whether Ripple received fair notice. I can now see there being no settlement, and the parties let the judge decide via Howry. In other words, view the fair notice defense as insurance. It's an issuance policy that kicks in if Ripple loses on a Howry application. Thus, I'm leaning on no settlement in a decision by the judge. The timing of a decision depends on how long it takes Judge Torres to decide. So, quite honestly, when I read this, I'm thinking, oh, more and more time. But, when I kind of get my emotions out of it and I kind of step back and see, I've been accumulating since late 2017, early 2018, been waiting this entire time. Obviously we got hit with the lawsuit in December of 2020. So it's like, okay, how much longer are we really going to have to wait? Yeah, it's frustrating, but it's like, as long as things are done the right way, Ripple, wins the case, XRP gets the regulatory clarity it needs to flourish and to be set free in a sense, get those shackles off of it, then, that's all that matters. But it is kind of disheartening to see like this can potentially go on, as they say, to like November, December in regards of, it actually going through the full adjudication. Now, if there's a settlement, it can happen at any point. So who knows what's going on? Digital asset investors always talking about, all the world's a stage in regards to kind of what's been going on and what's been surfacing. So you don't really know, what the conversations are in between, Ripple and the SEC or, the powers that be. We don't know if it's all orchestrated in a specific scenario. Like who knows what's going on? All we have is the facts, being, the outside YouTubers and Twitter sleuths and investigators and a community, a decentralized community at that. All we have is the facts that, we are presented with in regards of them in their own words, their own documents. So we don't really know what's actually going on behind the scenes. So now if the case does go through full adjudication, obviously we're going to be waiting a little longer. Now, if there's a settlement, it can happen at any day, which will be absolutely massive. But as long as things are done the right way and Ripple wins, XRP gets the regulatory clarity it needs, that's really all that matters. So coming over here, Stefan Huber put up this video here. He says, I found out why the video from the GC Tech conference is so important for Ripple. Heyman was asked in an interrogation if he knew of a video recording of his talk from that time. Unfortunately, none of us could find a recording, but here's Mike Heath talking about Hinman, stating that if the blockchain was funded and made functional by classic venture capital, that these tokens would then no longer fall under securities laws. This, of course, is a bombshell for Ripple's fair notice offense. So absolutely, obviously, if us, that's been involved with investing in XRP and being involved with, the case, kind of following it step by step, been a part of the, the XRP community, XRP army, we know that when it comes to, how Ripple was funded, it was through venture capital. Now we know Ethereum held an ICO. So clearly stating, it was a security at once. But now you have Ripple, or excuse me, when it comes to the issuance of, excuse me, let me retract here. So pretty much what he's saying is there's no way that the things that Hinman was stating in regards of the truth, meaning XRP, Ripple, we can put them interchangeably. It doesn't matter. We know Ripple is a company, XRP is a digital asset. So XRP does not fall under securities laws because there was no ICO. It was everything was funded in regards of venture capital money. So now he has this video here that we're going to take a listen into.
And Director Hinman at the SEC has given a speech back in June and then just kind of reiterated again last week in New York to the Tech GC conference that he does believe that there are tokens that are not securities and that there is a model to fund these projects without without violating securities laws, but kind of his position is the vast majority of these things still are securities offerings, which means you have to comply with all of the securities offering rules. I mean, Director Hinman's opinion is that you should be funding these businesses through kind of a conventional venture financing model, and then once the technology is up and off, kind of you can stand it up, then you can kind of move on to the next phase, which would be kind of a more public token offering. I think it is interesting, though, the SEC has not really brought any actions on a pure securities law violation. Almost every single action they've brought that I'm aware of has either involved material misrepresentations or outright fraud. And there haven't been, as far as I'm aware, any straight just violation of the registration provisions of the Securities Act to date.
So, I mean, all of us that's been a part of this, we know. I mean, it's the same stuff over and over. And obviously, we're just surfacing, or thanks to Stefan Huber and, all the other people out there really trying to surface all this stuff, just surfacing more facts that strengthens, the Ethereum free pass timeline, strengthens, Ripple and XRP's position in regards to the market. So, clearly, we all know this stuff. So, let's continue on here. I'm deciding if I want to go through this, but this is from Bill, and he has some great insight and interpretation in his threads in regards to kind of what's been going on. So I'm going to try to quickly run through this one. So he says, what is the common enterprise between Ripple and XRP holders in relation to XRP token, given the SEC alleges a continuous offering by Ripple for 8 years? How can this be maintained in the face of an XRP ledger that has been fully functional since 2012 with its owned native DEX? Absolutely. So he continues, this is a prong of the Howey test that the SEC seems not to wish to draw attention to, including in the 2019 framework document, in which it is barely mentioned and assumed to be satisfied for digital assets, or not even a distinct element of the Howey test. Perhaps then it is not surprising it is referred to only it's only referred to 4 times in the SEC's amended complaint. You will not find it easy to understand the SEC's position if you look at these few references. It says extracts following what it is that the SEC asserts in a common enterprise. The problem for the SEC is that Ripple's building of the ODL and RippleNet happened in the context of existing fully functional XRPL, but they are not the same thing. Ripple has said that the XRPL would continue to function without Ripple, and there have been many other projects that do not require Ripple. The point is that the SEC does not distinguish between the ODL use case for XRP and the XRPL and the XRP coin itself. What is the enterprise which the SEC believes is a common enterprise involving Ripple and XRP holders that concerns all offers of XRP? It cannot be building the XRPL, which was already fully functional and permissionless in 2012. Can it be improving or changing the protocol? But that cannot apply to the continuous offering for 2012 and 2020 if some or many offers of sales were not to raise funds to improve the XRPL. The SEC asserts at least once that the common enterprise was increasing the liquidity of XRP, creating liquid markets, and thereby its value but what if some offers to sell XRP were to fund Ripple's operating costs, which is one of the SEC's references to common enterprise? In the amended complaint, in terms of offers of sales of XRP connected to development ODL, which the SEC acknowledges is a product, why is the common enterprise not more naturally between Ripple and its ODL partners using XRP for cross-border payments rather than an XRP holder? In respect of these particular sales of XRP, in terms of vertical and horizontal commonality, how is there constant commonality for a continuous offer to sell XRP for 8 years, even in secondary markets? I looked at the amended complaint of the SEC for answers to this question, but could not find them in the scant few references to common enterprise. Johnny Deaton has recently tweeted that one of the huge mistakes the SEC made was not to specify specific offers of sales limited to certain times. It certainly has not helped in terms of the common enterprise prong of the Howey test to assert one continuous offer for 8 years. It seems the SEC seeks to overcome this problem by, in confusing utility with degree of adoption. The assertion of XRP has no utility. What an erroneous assertion. Proving a common enterprise is far from a sure thing for the SEC, which is why it's glossed over. The SEC has the onus and burden of proof in proving a common enterprise. It hasn't even clearly identified or peeled it in the amended complaint. As Perkins Coie stated in their advice to Bill Hinman on the 26th of March 2018, it's a very significant hurdle for the regulator to overcome in court. Perhaps the common enterprise for the SEC is Ripple's entire business for 8 years, but how is that reconcilable with the fact that XRPL could continue to function and XRP be sold without Ripple? How can XRP by itself nature be a security per se? I'm not saying the SEC doesn't have a cognate position on the common enterprise prong of the Howey test. I just can't see it expressed clearly in the minute complaint. So this goes back to kind of what we were just talking about in regards of, let me come back here. What was that, Stefan Huber? Yeah. So we're talking about this. So if you're talking about a common enterprise between Ripple and XRP holders, and you're claiming that all XRP sales, even the ones sold in the secondary market, are securities. But it's like, okay, well, what are you comparing it to? You give Bitcoin and Ethereum the free pass, that Ethereum free pass timeline that we're talking about, William Hinman's speech in 2018. But it's like, okay, well, Ethereum held an ICO, but there's no security status there. But, there was a venture capital, collection of money in regards to, in a sense, fund what was going on the Ripple, and XRP side. So if you're comparing, ICO versus venture capital, it's like, well, you're stating here, based on Hinman's own words, that there's no way that this should be fall under securities laws. But then you claim Ethereum doesn't fall under security laws, but it held an ICO. It's crazy. Long story short, he kind of broke it down in his kind of own opinion, and I thought it was pretty insightful. Great thread, Bill. Thank you. So now moving on from the Ripple versus SC stuff, U.S. officials linked North Korea Lazarus group, hacker group, to 625 million Axie Infinity crypto theft. So obviously that's kind of what the narrative is this group of Lazarus hackers are a part and are behind the Axie Infinity stuff, and they're utilizing that Tornado platform where they're sending a certain amount of I think it's Ethereum. Yeah, they're sending a certain amount of money into this, trying to like tornado it and trying to make it harder to track. So we're going to continue to follow this case, or I guess we can say this story, and kind of see what the updated timeline is. Coming up here, says Metamask warns users of new Apple iCloud phishing scam. Crypto wallet Metamask is ringing the alarm bell on a possible phishing scam attacks through Apple's iCloud server. So if you come down here, the tweet says, if you have enabled iCloud backup for app data, this will include your password and crypto Metamask vault. If your password isn't strong enough and someone phishes your iCloud credentials, this can mean stolen funds. You can disable iCloud backups for Metamask specifically by turning off the toggle here. You go to settings, profile, iCloud, manage storage, backup. So make sure that you're doing everything in your power to be very diligent about protecting your assets. I hold a Metamask wallet just like a lot of other wallets out there, but if you're a part of this, make sure that you're doing everything in your power to protect yourself, because they're out for your money. They're out for your crypto. All right, moving on here. Here we go. Kevin O'Leary, man. This guy's literally jumping, head first into the crypto space. He goes from having high reservations against it to now just fully jumping into it. So Kevin O'Leary backed WonderFi to acquire Canadian crypto exchange Coinberry for $38.5 million. WonderFi plans to expand its operation in Canada by acquiring digital assets trading platform Coinberry after its recent BitBuy acquisition. That's absolutely massive. Hats off to Kevin O'Leary. Jumping in, he sees where this future is going. The writing is on the wall when it comes to the crypto space. In all the sectors within the crypto space, and these platforms, these trading platforms, and just these platforms in general, the on and off ramps, and whether it's a platform for trading, or we're talking about for swapping, or whatever the case is. This is absolutely massive. So hats off to Kevin O'Leary for jumping full in. I know if I had the funds and the money, I'd find a way to try to jump more into the space and get more involved and kind of put my tentacles in a whole bunch of sectors within the crypto space. So ending on this one, says Terra stablecoin UST becomes crypto's third largest. The dollar-pegged UST has overtaken Binance USD to become the crypto's market's third largest stablecoin by market capitalization. So obviously, if you've been following the crypto space, or even this channel, we kind of been talking about, how massive Terra and UST have been coming. So if we come back over here and look at this, Terra sitting at 18.3%, for a 24-hour period. So obviously there was a huge spike in regards of the movement, based on, this news and kind of what they've been doing. So let me come back here and go to the front page real quick. 20-minute video. So Terra, That's absolutely positive, man. I mean, they're doing great stuff. Obviously, they're backing, their USC stablecoin with, I think they bought like a bunch of AVAX. They're backing it with, I think, up to 10 billion of Bitcoin. I mean, it's absolutely crazy. This is crazy. Long story short, hats off to Terra and their community and their, their owners and leaders. That's absolutely huge. But, all in all, this is kind of what's going on in the space right now that I see. It's kind of my take and insight on kind of what's going on. But with all that being said, stay strong out there. Be safe.